learn with me. I did another one earlier today. Some of you might have been present, maybe, maybe not. So I actually wanted to start this one off doing something just a little bit different, just a little different, okay? Just a little bit. If you don't know anything about criminal law, right? I want you to know that this is still a good, safe space to be in. Just learn with me, right? Because you don't have to know anything about criminal law to answer the first question I'm going to give you. Are you ready for the question? Okay. Imagine somebody seriously injures another person, right? Imagine somebody seriously injures another person. The injured person gets to the hospital, okay? The doctor says, we can save you. You just need this treatment. Okay, but the injured person says no. They refuse the treatment and they die. They pass away. Who caused the death? The question, who caused the death, right? Was it the person who caused the original injury? Was it the person who refused the treatment? Was it both? Or are you already thinking, okay, I need some more facts? That would be plausible. That's where I'm sitting. I want more facts, right? The person who caused the original injury, the person who refused the treatment, somewhere in the middle, you're like, I need some more information. Okay. So if you're coming into the live, put your answer in the chat. See, we got a couple people here. Put your answers in the chat. I got my computer also up. Y'all see me going like this. So I can actually engage with you guys in the chat as we move through this line with me, okay? Because I really want y'all to feel like this pressure. I want this to be really low pressure as I'm working on this and studying. I kind of want to make something we can both kind of vibe with. So if you come into the live, I want you to put your answers in the chat. There really isn't any pressure to know like legal rule quite yet, because once again, y'all just learn with me, and as I'm learning this material, I want you to know what your instinct tells you before we start like applying law. That's what I kind of want to think about, because that's what I've been doing. I like to think what my instincts tell me first, like, well, how do I feel when I look at some of this stuff, and then I start saying, okay, what does the law say? Because the law is super prescriptive, right? So we're pretty much doing a continuation of topic 4, which is causation. So that's what we're going to be studying once again in the chat. Okay? So once again, if y'all popping in, throw something in the chat. Let me know what y'all here. Some people have been at other Learn With Me sessions I've done. Some people haven't. Once again, this is a situation where I want you to feel super comfortable being able to just jump in. I'm going to have my notebook LM give us some stories, right? And we're going to listen to it together. But once again, I'm going to try to make this real comfortable. This is a continuation of topic 4, which is causation, in my University of London criminal law material. And we're right now I'm going to actually have us focus on a part which is R versus Blaue, and making the facts considerably more complicated, basically for the question I just posed to you guys. So in Blaue, I'm going to give you all a little bit of description on that one. The defendant stabbed the victim, right? She suffered serious blood loss, but she refused the blood transfusion. This is where it gets interesting, right? So she refused the blood transfusion that the doctor told her she needed, but she refused it because of her religious beliefs. Okay? So unfortunately, she passed away. The defendant tried to argue, essentially, I'm not the cause of this death, right? Because, well, we'll go there. They said, I'm not the cause of this death. She said, let me see. They said that they weren't the cause of death because she could have received the transfusion, the blood transfusion, and lived. So they said they weren't the cause because what she refused. Okay? But the Court of Appeals rejected that argument. The principle, right, we're working with is that the defendant must take the victim as he finds them. You don't just get to pick and say, hey, you know, if in an ideal situation, if they was healthier, they would have survived. You don't get to pick and choose. You have to take the victim in this situation as they are, right? So now we didn't level set, right? We got the same baseline right there, right? The original stabbing remains a substantial and operative cause of the death, which was what that basically was saying. Y'all got that? That sound straightforward? Give me some movement in the chat. Then I'm going to finish this piece and I'll put it up. Okay? So So I'm actually going to share with you guys something that happened in my course, because my course actually gives me a much harder version that we're going to start to work with, right? Now we're going to get this vignette that I'm put once again through this notebook LM, which is going to give us basically like a whole podcast so we can listen to it, we can kind of peruse through, chew on it, kind of come up with some ideas, right? In this case, Eve is terminally ill. She wants to pass away, right? She wants to die. And she asks her husband, Adam, to shoot her, unfortunately, right? Adam agrees and shoots her, but the shot doesn't kill her. It does not take her out, right? Instead, it causes massive internal bleeding. Then Adam changes his mind, right? Adam actually changes his mind. He decides he doesn't want to be responsible for Eve's death. So he takes her where? He takes her to the hospital. The doctor tells Eve, you need a blood transfusion. If you don't receive it, you're going to pass away. Eve said no. Remember, Eve wants to die before Adam even shot her. She refuses the transfusion because she still wants to pass away. She then passes away. Now tell me this. I want y'all to listen. Now tell me this. Did Adam cause Eve's death? Did she cause it death? Because this is where I'm having to really work through the difference between saying something is a factual cause and like deciding that it should be recognized as like a legal cause. And my course isn't really giving me a neat little answer to tell me how to like memorize these kind of situations, which is why I want y'all to learn with me and it's to kind of walk through it, because I really enjoy being able to have like dialogue and people say, okay, like think about this, consider that. I go to my computer, go jinkies, and then I get to typing stuff and I get to looking up stuff. So essentially I want us to kind of work through this stuff together, if that makes sense, right? We're specifically being asked to like exercise what moral and common sense judgment and decide whether there's a significance enough to like difference between the facts and like Blaue to distinguish the case, which is like one of the areas where I'm like, okay, so that's what we're gonna be doing tonight. Like I said, I want to look at my notes, make sure I'm giving y'all all the tea. So once again, we're gonna listen to notebook LM discussion. We're gonna work through the argument on both sides, because you know how I am. I like to always be fair, so we're gonna look at both sides. And I'm gonna stop periodically and put some questions in the chat. And hopefully that makes sense so far what we're doing. And if you're just wondering, you can absolutely participate at any point in time. Throw it in the chat. I will be engaged with the chat. Right now, I'm just looking at my little notes real quick. And then I'll be able to jump back to the screen where I can respond to some comments. I do see some movement that's happening. I will be responding. Don't you worry. I love that part. Okay. So if you don't know what novus actus intervenes means, I'll give you the facts. Okay. You tell me what you think is fair. Then we'll see what happens when we put the criminal law rules on top of your answers. It's pretty much how this is going to go. Okay. So I'm about to start the podcast, but I'm going to put the first question in the chat. Y'all ready? I'm going to throw the very first question in the chat. I'm actually going to also go in, make a little quick response to some of y'all, and I'm going to go ahead and play the podcast. Y'all ready? Any questions before we jump right on in? Any questions? Hey, this is doing my learn with me. Criminal law deep dive. Case study. I almost saw one of the case study ones. That's another series we do if you're interested. Popped up on the screen. Okay. I don't see any immediate questions. I'm going to go ahead and start to play this version of the podcast. Y'all ready? In 5, 4, 3, 2, 1.
So if you beg your partner to end your terminal suffering, and they pull the trigger, but you survive long enough to refuse life-saving medical treatment in the hospital, who is actually legally guilty of your murder?
Right, yeah, it's such a heavy question.
It really is. Today we're doing a deep dive into a stack of legal source material on causation. We're trying to figure out why the law sometimes treats, an act of desperate compassion exactly the same as an act of cold-blooded killing. Specifically, we're looking at Wilson and Lemazzini's breakdown subsisting conditions, and how courts determine legal responsibility when a chain of events just turns into a total mess.
It really forces us to reconcile the rigid mechanics of the law with, the incredibly messy reality of human autonomy.
Yeah.
Because when multiple factors contribute to a death, like a gunshot and a doctor's mistake and a victim refusing care, pinning down the definitive cause isn't just science anymore.
Right, it's like it's a moral judgment.
Exactly. It's a deeply complex moral judgment disguised as a legal test.
And to anchor this whole discussion, we're going to use this specific, really morally gray thought experiment straight from the reading. So let's set the parameters here. We have a husband and a wife. We'll call them Adam and Eve.
Okay.
Eve is terminally ill. She's in absolute agony, and she desperately wants to die. So she asks her husband, Adam, to shoot her.
Right.
Out of compassion, he agrees, he fires the gun, but he fails to kill her instantly. Instead, the gunshot causes massive internal bleeding.
Which leaves us with this terrible situation that's about to get incredibly legally convoluted.
Yeah, because at this moment, Adam panics. He's stricken with guilt. He realizes he doesn't want her blood on his hands, so he rushes Eve to the emergency room. And the doctors assess her and say, look, she needs a blood transfusion immediately to survive.
Yeah.
But Eve's intention hasn't changed. She still wants to die.
She's consistent, yeah.
She refuses the transfusion, and shortly after, she passes away. So the question we have to wrap our heads around today is Adam the legal cause of Eve's death?
Well, to unpack that, we really have to split the legal concept of causation into two totally distinct layers.
Okay.
The courts don't just look at the final outcome. They start with a very strict scientific baseline, which is known as factual causation.
Factual causation.
Yeah, and this is established using the but-for test. We're asking this purely historical question, like, would the result have occurred but for the conduct of the accused?
So if we look at the 1910 case of R.V. White from the material, we can really see how narrow that factual baseline is.
Oh yeah, White is a classic example.
Yeah, in White, the defendant put cyanide in his mother's drink because he wanted to kill her. But before the poison could take effect, she died of a completely unrelated heart attack.
Which perfectly isolates the factual test, because the court asked, but for Mr. White poisoning the drink, would she have died at that exact moment?
And the answer is yes.
Yes. The heart attack was happening regardless of his actus reus. So because his action didn't physically alter the timeline of her death, he wasn't the factual cause. He was convicted of attempted murder, sure, but he completely avoided the murder charge itself.
So the but-for test acts like this wide net. It catches everyone who played a physical role in the events, but it doesn't assign moral blame quite yet.
Exactly.
It's like looking at this huge line of dominoes and just asking, hey, did your finger tip the first one over? If the final domino was going to fall anyway because the table collapsed, you aren't the factual cause.
Right, great analogy.
Okay, let's unpack this for our scenario. Adam definitely knocked over the first domino, but for him pulling the trigger, Eve wouldn't be bleeding out in that hospital.
No question. He undeniably satisfies factual causation. The scientific link is unbroken.
Okay.
But clearing that baseline is just the beginning. The much higher hurdle is the second layer, which is legal causation.
Right.
This is where the court transitions from historical fact to actual moral culpability. To be the legal cause, the Defendant's Act has to be a substantial and operative cause of the final harm.
Substantial and operative.
Yeah, the law intentionally filters out trivial contradictions.
And this is where the source material introduces the concept of subsisting conditions, specifically through the thin skull, or the eggshell skull rule.
Right.
The principle that you basically must take your victim as you find them.
Yes.
Yes.
And the 1908 case of Hayward illustrates this brutally. A man was chasing his wife, threatening her with violence, and during the chase, she collapsed and died of a heart attack.
Just from running away.
Well, unbeknownst to the husband, she had a rare thyroid condition that made her uniquely susceptible to severe fright.
Oh, wow. So it's essentially like a legal building code. You don't get a pass for knocking down a house just because you didn't know the foundation was already cracked.
That's a good way to look at it.
You swing the sledgehammer, you own the collapse. The law refuses to offer a discount on criminal liability just because the victim happened to be physically fragile.
That structural analogy holds up perfectly when we look at physical vulnerabilities, but the law actually takes it a massive step further. The courts determine that you don't just take your victim as you find them physically, you have to take them as you find them mentally and spiritually as well.
Which brings us to the R.V. Blaue case, the 1975 precedent.
Exactly, and this is central to understanding Adam's liability.
So in Blaue, a woman was violently stabbed after refusing her attacker's sexual advances. She gets rushed to the
Sugar alert.
hospital with severe bleeding, and doctors tell her that a blood transfusion is going to save her life.
Right.
However, she was a Jehovah's Witness, and her religious beliefs strictly prohibited accepting blood. So she refused the treatment. She died from the wound.
And at trial, the attacker's defense team argued that her refusal broke the chain of causation.
They tried to blame her.
Yeah, they claimed her decision was the true cause of her death, effectively trying to shift the blame to her religious convictions.
Wow.
But the court firmly rejected that argument. They extended the eggshell skull rule to encompass a victim's deeply held beliefs. Her religion was a subsisting condition, it was a part of who she was. So the attacker was held fully responsible for her murder.
So Wilson and Lemesnamy ask us to compare Blaue directly to our Adam and Eve scenario. And honestly, looking at the two, I see a massive structural difference that seems to warrant distinguishing them.
Oh, absolutely.
Because in Blaue, the victim was attacked against her will. She wanted to live, but she was constrained by a pre-existing religious tenet.
Right.
Eve, on the other hand, orchestrated her own shooting. She didn't refuse the transfusion because of a religious constraint. She refused it because her primary overriding goal was to die. So from a standpoint of human autonomy, treating an act of cold-blooded violence the same as a botched consensual mercy killing, it just feels logically flawed to me. Are the courts really that blind to the victim's original intent?
You're hitting on the exact tension that makes this area of law so debated. Morally, those two scenarios sit on totally opposite ends of the spectrum.
Right.
But legally, the courts look past the moral nuance and focus ruthlessly on the physical mechanism of death. I mean, if a medical examiner performs an autopsy on Eve, the cause of death is massive blood loss from a gunshot wound.
The hole Adam put in her.
Precisely. Just like the stab wound in Blaue, Adam's gunshot remains the substantial and operative cause of death at the exact moment she expires.
I see.
The legal framework prioritizes the physical reality of the wound over the victim's agency. An omission, like refusing medical treatment, rarely operates as a legal shield for the person who inflicted the lethal injury in the first place.
So the law values the sanctity of life over personal autonomy to such a degree that it effectively criminalizes compassion in end-of-life scenarios.
It does.
But if an omission doesn't break the chain of causation, what does? Like if Adam takes Eve to the hospital and the chaos of the ER, the medical staff intervenes and makes a lethal error, does that sever Adam's liability?
Well, this brings us to novus actus interveniens.
A new intervening act.
Yes. For an event to break the chain of causation, it must be so powerful and so independent of the original act that it renders the initial wound merely part of the historical background.
Okay.
When it comes to medical intervention, the bar for breaking the chain is just staggeringly high.
Which we see in the Cheshire case. A man was shot in the abdomen and required a tracheotomy to breathe. And the hospital performed the procedure negligently.
Very negligently.
Yeah. The gunshot wounds actually healed, but weeks later, the victim died from rare complications directly caused by the botched tracheotomy. Yet, the court still held the original shooter liable for the death.
Because the court recognizes that if you introduce a lethal threat into someone's life by shooting them, you inherently bear the risk of the medical friction that follows.
Because doctors make mistakes.
Exactly. Doctors operating in high-pressure trauma situations make mistakes. That human error is considered a foreseeable consequence of the original assault. The medical treatment in Cheshire was a direct reaction to the danger the shooter created.
So to break the chain, the medical error can't just be standard negligence. It has to introduce an entirely independent hazard, like the Jordan case.
Yes. In Jordan, the stabbing victim was actually recovering. The original wound was no longer life-threatening.
Wow.
But the medical staff administered a massive dose of an antibiotic that the patient had already shown a severe allergic reaction to.
Oh man.
Yeah, that documented gross negligence was so overwhelming, so palpably wrong, that it eclipsed the original stab wound. It wasn't expected friction, it was a completely new, independent cause of death.
So a doctor's mistake almost never saves the defendant unless it's catastrophically incompetent.
Pretty much.
But let's pivot back to the victim's own actions, because Eve isn't a passive participant here. She actively intervenes by refusing care. To evaluate victim interventions, the courts use what's informally known as the Daphnis test. Right?
Yeah, the Daphnis test. It's a test rooted in foreseeability. It's usually applied when victims are injured while trying to escape an attack.
Okay.
The core rule is this: if a victim reacts to a danger in a way that is reasonably foreseeable, the chain of causation remains intact.
Got it.
If their reaction is completely unforeseeable, disproportionate, or daft, the chain is broken and the attacker is no longer liable for the subsequent injuries.
And the source material contrasts two escaping cases to highlight this line.
Yeah.
Like in Roberts, a woman jumped from a moving vehicle to escape a sexual assault.
Right.
And the court ruled that jumping was a foreseeable, reasonable fight or flight reaction to that specific threat. The driver was held liable for her road injuries.
Now compare that to Williams and Davis, where a passenger jumped from a moving car because he suspected an attempted robbery was about to happen.
Oh, just a suspected robbery.
Right, and he tragically died in the fall. The court determined that leaping to your death to avoid a potential theft was an unforeseeable, disproportionate reaction.
It was daft.
Exactly. It was deemed daft enough to break the chain of causation.
Here is where it gets really interesting, though. Applying that foreseeability test to our scenario completely neutralizes Eve's refusal as a defense for Adam. Because Eve's rejection of the blood transfusion wasn't an unforeseeable surprise. It was 100% predictable to Adam because her desire to die was the entire catalyst for the shooting in the first place.
Yes, exactly.
So under the logic of Roberts, her refusal is entirely foreseeable, which means it cannot constitute a new intervening act. The chain remains unbroken.
That is the inescapable legal trap Adam is in. When a victim's actions are entirely predictable to the defendant, it becomes legally impossible to argue those actions are independent, chain-breaking events.
Wow.
Even though Adam changed his mind and tried to save her, he set a predictable sequence of events in motion.
Which pushes us into what I think is the darkest and most conceptually difficult area of the source material. Cases where a victim's trauma leads them to actively choose death, completely separate from refusing medical care.
Right.
How does the law handle suicide following criminal act?
Historically, criminal law viewed suicide as the ultimate independent choice. It's a decision typically influenced by a myriad of life's vicissitudes, prior trauma, depression, social factors. So, if an individual was assaulted and later took their own life, the courts treated the suicide as a novus actus interveniens. The attacker would be guilty of the assault, but the chain of causation for manslaughter or murder was considered broken by the victim's autonomous choice.
Because it's practically impossible to prove beyond a reasonable doubt that a specific assault was the sole operating cause of someone's decision to end their life months or years later.
That was the traditional barrier, yeah. However, the source material highlights how modern courts are beginning to challenge that assumption.
Oh, really?
Yeah, in the case of Dhaliwal, which involved a tragic suicide following relentless domestic abuse, the court suggested a theoretical pathway. If a suicide is immediately triggered by a final physical assault, acting as the culmination of that abuse, the jury might be entitled to find that the final blow caused the death.
That requires a very tight temporal connection, though. But then we look at the 2017 case of Wallace, which just completely stretches the boundaries of how we define a subsisting condition.
Wallace is a very heavy case.
It really is. In Wallace, the defendant threw concentrated sulfuric acid over her former partner while he slept. The physical destruction was just catastrophic. He was left blind, severely disfigured, paralyzed, and in agonizing continuous pain.
And crucially here, 2 full years passed. After enduring 24 months of relentless suffering, the victim traveled to a clinic in Belgium where euthanasia is legally sanctioned, and he chose to have his life terminated.
A 2-year gap, combined with a deliberate state-sanctioned medical procedure in a foreign country. I mean, by all traditional metrics, that amount of time and deliberate action should sever the chain of causation.
You would think so.
The trial judge certainly thought so. They withdrew the causation question from the jury, reasoning that the victim's choice was a new intervening act.
But the Court of Appeal overturned that decision, and their reasoning is profound. The appellate judges ruled that a jury could absolutely conclude that the victim's decision to pursue euthanasia was a direct, inescapable response to the horrific injuries inflicted by the defendant. The acid attack was still the operating cause of his unbearable condition.
So the appellate court essentially ruled that psychological destruction is a direct continuation of physical destruction.
Yes.
The original wound was still operating conceptually because the attacker didn't just destroy his tissue, they destroyed his capacity to endure existence.
Exactly that. The court framed the euthanasia not as an independent choice made in a vacuum, but as a medical response to an untreatable, continuous agony created by the defendant.
Wow.
The legal question for the jury wasn't whether the victim made a choice, but whether the accused acts made a significant contribution to the conditions that made that choice inevitable.
Bringing this massive weight back to Adam and Eve, we see how tightly the net closes on an atom.
Yes.
Eve's refusal of the transfusion is a deliberate, informed choice, much like the victim in Wallace choosing the clinic. And while her initial choice is rooted in her pre-existing terminal illness, her subsisting condition, the acute physical reason she is dying on that hospital bed is the gunshot wound.
Yes. The courts, synthesizing Blaue, Trescher, and Wallace, remain remarkably consistent on this front. If the original wound is still an operating and substantial cause of death, the defendant is liable.
Right.
The law operates on the fundamental principle that an individual cannot consent to their own murder. Once Adam sets that lethal mechanism in motion, his subsequent regret and Eve's subsequent refusal of care cannot legally distance him from the fatal outcome.
We started by wishing the law was as precise as an X-ray machine. We want clear demarcations between guilt and innocence, especially when compassion is the motivating factor.
We don't want that.
Yeah. We walk through factual causation, the but-for test, which is just the scientific groundwork. But the deep dive into legal causation reveals a landscape governed by rigid policy. You take your victim as you find them, regardless of their hidden physical flaws or unyielding religious beliefs.
And we observed just how impenetrable the chain of causation really is, whether it's expected medical friction in an emergency room or a victim's foreseeable refusal of treatment. The original aggressor rarely escapes liability.
Right.
The law stubbornly insists that once you introduce a lethal hazard, you own the ripple effects.
If you're listening to this and thinking these concepts only apply to extreme cinematic scenarios like euthanasia or poisoned drinks, it's worth noting that these exact standards of foreseeability and subsisting conditions impact everyday law too.
Oh, absolutely.
They govern personal injury claims, car accidents involving drivers with pre-existing conditions, and workplace liabilities where human error is a foreseeable risk.
Which leaves us with a lingering systemic tension regarding the Daphnis test.
Yeah, that Daphnis test.
Because the law dictates that a chain of causation is broken if a victim's reaction to a threat is deemed unreasonable. But human beings process trauma in wildly disparate ways.
They really do.
What registers as a logical fight-or-flight response for one person might look utterly absurd to a jury sitting safely in a sterilized courtroom a year later.
It's an incredibly subjective bar for a judge or jury to set.
It is. I mean, if criminal liability ultimately hinges on 12 people deciding whether a victim's panicked, traumatic reaction was reasonable or daft, aren't we essentially putting the victim's psychological behavior on trial just to figure out if the attacker is guilty?
That is a phenomenal question to leave hanging in the air. The law attempts to mathematically quantify human panic and choice, but it ultimately relies on the messy, subjective interpretation of jury. Thank you for joining us on this exploration of causation, subsisting conditions, and the legal limits of autonomy. Keep questioning those moral gray areas, and we'll catch you on the next deep dive.
What y'all thinking? Y'all heard the podcast. It was a good podcast, wasn't it? That one was good. I had maybe two that was a little iffy, you know. Well, more so one that was a little iffy, and I had to go and do some refinements. That one came out good. What do y'all think? What do you think? Okay, factual causation asks, did D make the difference, right? Legal causation asks the harder question. Should this result be attributed to D? And that's where this stuff gets interesting, right? It's really interesting because it's not like what you think about when you think of like your like day-to-day situation, right? We're not quite looking at it through this prescriptive lens, but for the purpose and for the practice of this, we kind of have to, right? But it's interesting. It's interesting. And it's something I've been trying to wrap my brain around. So hopefully you guys like this Learn With Me session. Today has specifically been focused on causation because I was like, you know, I kind of want to ingrain this content into my mind, right? I want to make sure that I'm processing it. So I kind of put a little bit of the formula down at the bottom. Feel free, once again, even once live is over, it goes into replay mode, then it goes right on the channel. So you didn't miss anything. When I do my Learn With Me sessions, do not feel like you also have to be a law student or pursuing to be a law student to be able to participate in this. This is something I wanted to make accessible to everybody. That's why it's on my YouTube channel. I'm doing this. I just off the gusto, just for the love of it. You ain't like I'm being compensated or monetized or anything like that. So literally, your engagement helps as I process this material. I really enjoy this experience, and it's just really helpful when I kind of get to just talk to y'all and kind of see how y'all processing things too, and kind of gives me something to chew on, because you might see or hear something different than I heard, and it might get me in one of my modes. I'm like, Jinkies, and I go in here and I type and add on to it, right? So hopefully you enjoyed this learn out loud session that we were able to kind of talk about, because I think it's really interesting when you add in the medical elements, right? I feel that given current events in my native land, which would be the United States, it's always interesting when you think about the power and authority when it comes to medical situations. Like, what does the law say? What is that discipline saying? Like, how do they intersect? How do they interact? How do they communicate? And as someone who comes from having historically mental health background, I'm always interested about those intersectionalities. So when I was able to get this to link up in this particular study session, I was like, we have to see how that looks. I just love listening to the case studies and the case law and kind of seeing how they map. Y'all know I'm always interested in mapping things and connecting things. So this was a special treat. Hopefully you enjoyed it. Once again, this is Legally Everywhere with Child. We legally everywhere, looking into any and everything. If you have not been before, please go ahead to comment, like, subscribe on the channel. It lets YouTube know that, in fact, this is good content, that you think it's worth sending to other people. You think it's worth building out this community so that we can have more people in the chat talking, learning, growing together. But more importantly, making sure we have these discussions. I don't feel like these conversations should be taboo. I don't think that they necessarily always need to be gatekept and held somewhere else. I think any and everyone could benefit from knowing this information, thinking about processing situations through this lens, right? So I want to share it with you all. Hopefully you all have enjoyed it. Once again, if you didn't catch me live, you can always catch me. Well, you can catch me in the videos. You can catch me in the shorts. You can catch me in the little long forms, which once again just comes across as videos for y'all. My content will be there. Hopefully you enjoyed it, and you can catch me in the next live. Until next time. See you. Have a wonderful day, and take care of yourself. Practice self-care.